Welcome everyone. This is the final session of the fifth weekend of the Ibis Prep Florida Bar Crash Course, and we're going to be talking about trusts and family law. And we learned a great mnemonic this morning for trust, which is valid trusts don't ruin marriages. And this stands for the validity of the trust, the type of trust, the duty of the trustees, removal powers, and modification. And right now, I'm going to go through the outlines that I have on my drive and just add a little bit more flavor to what Will provided this morning. So this is one PowerPoint that actually I think I created, but I think I may have given Sam credit for it. But the elements, and I do mean that, I'm not trying to diss Sam. I love Sam. She's amazing. But the elements of an express private trust are settlor, legal intent, trustee, trust raised plus delivery, ascertainable beneficiaries, and a valid purpose. And like we said, real property and testamentary trust must be in writing. I know this morning there was a discussion about money involved. Don't remember that. Remember this: real property and testamentary trust must be in writing. Settlor, legal intent, trustee, trust raised plus delivery, ascertainable beneficiaries, valid purpose. Real property and testamentary trust must be in writing. Some types of trust, some key terms. We talked about Dunks. That was the amazing mnemonic. Does anyone out there feel confident they can remember what Dunks stood for? I'll take a stab at it if no one else wants to. Testamentary trust is T. The R is
resulting, revocable, irrevocable.
Resulting, revocable, and irrevocable. Okay. The S?
S is spendthrift.
Spendthrift, okay. And then the I?
Vivos.
The D?
Discretionary. D, oral. There's no oral in.
O is oral.
Yeah, N is no contest. There's no contest in Florida.
No contest. And then C is charitable.
Charitable.
And S is?
It's for secret and semi-secret.
Secret, semi-secret. And wasn't there another thing that S stood for?
Yeah, support trust.
Support trust. And then I also talked about honorary trust because I am a dog lover. So that was cool. Dunks was one of those acronyms, mnemonics that we'll try to never forget. So we have inter vivos trust, created while the individual is alive. Testamentary trust, created upon the death of an individual, must be in writing if created after 2007. That's the precise language. Revocable trust, a living trust which can be changed. Irrevocable trust cannot be modified without the consent of all the beneficiaries. Precatory language, insufficient to create a trust. It is my hope that will not create a trust. And then spendthrift provisions, which I'll go into more, super important. Protects a beneficiary against a creditor, attaching prior debts against the beneficiary's inheritance, as well as preventing the beneficiary from acquiring debt based on the future inheritance. Other types of trusts, UTMA and UGMA, I don't think these are going to come up. I have a habit of bringing my business mind into this world, but these are just like official trusts that you can set up. Uniform Transfer to Minors Act. Constructive and resulting trust. Resulting arises if an express trust falls apart, and then a constructive trust arises to prevent unjust enrichment. So a court will create a trust, perhaps, or unjust enrichment, which kind of brings up my favorite word, ill-gotten gains and restitution. But yeah, constructive trust is just created if it's necessary. And then secret versus semi-secret trust, we talked about this morning. Secret trusts are devised to a person in a will and are enforced by courts, and semi-secret trusts are mentioned in a will with no beneficiaries and are not enforced. Let's clarify that. I think we actually had that confused this morning. Secret trusts are devised to a person in a will and will be enforced. Semi-secret trusts are mentioned in a will with no beneficiaries and will not be enforced. So the difference between a secret and a semi-secret trust is that the secret trust has beneficiaries mentioned in the will. Like no one knew about the trust until the will, but it names the beneficiaries, it will be enforced. A semi-secret is it's named in the will, but it has no beneficiaries, so it's going to fail. So anyone who watched the video this morning, make sure you're clear on that secret trust will be enforced, semi-secret will not be enforced. And we're all human, but now that's why we leave no stone unturned. Totem trust is payable on death account. If you think about that, a totem trust is just like when you die, it'll transfer to that person. And then a pour-over trust is usually in a will. It has the same settlor and trustee, and it can be added to a trust during a life. So usually a pour-over trust also comes from a will. These are just, some language words to look at, just because on test day, you don't want to be like shocked by any language that you've never seen. But the main thing I like is, the Trissy dunks, and that are the main types of trust. But this is some other language that we could see. Who can penetrate a spendthrift provision? We didn't go into that enough this morning for my liking. Child support or spousal support, a judgment creditor who provided services for protection of a beneficiary's interest in the trust. We didn't mention that. A lawyer who works for the trust to make the trust, they can pierce the spendthrift provision. And then a claim of Florida or the United States to the extent provided by Florida federal law, right? The government. So the government, child or spousal support, and then remember, a judgment creditor who provided services for the protection of a beneficiary's interest in the trust. So if you hire a lawyer who's representing a beneficiary, that lawyer can pierce the spendthrift provision. And then the last thing, Nemo Dat, that has nothing to do with anything. I don't know why I put that in there. All right, cool. So that was just a little PowerPoint to supplement what we did this morning. Don't be afraid to fail. It's not the end of the world. And in many ways, it's the first step towards learning something and getting better at it. By John Hamm. I don't know who that is. Does anyone?
You don't know John Hamm?
No, I don't. Is it a soccer player?
No, if it's who I'm thinking of, it's an actor.
Okay, yeah, I don't watch that much. What does he do?
Isn't he the guy from Mad Men?
Yeah, exactly. I didn't watch Mad Men, but I know that that's like his.
Neither did I, but I think that's what he's famous for.
He's in a lot of Black Mirror episodes.
My former social media marketing person, Sonia, definitely put that in there because she watched that show, Mad Men. Now I'm kind of seeing John Hamm in my mind. He's got like a chiseled jaw structure.
Yeah, big chiseled dude.
All right, yeah, okay.
He's in randomly in a couple of progressive
yes.
ads with, what's her name? Flo.
Flo, yeah, they're great.
He has a crush on her and she doesn't. It's fun. They're funny. Anyway.
Yeah,
I gotta see that. Definitely no Flo. But anywho, trust. Valid trusts don't ruin marriages. The validity of the trust. Does it have these elements? Settler, legal intent, trustee, trust race, ascertainable beneficiaries, valid purpose, real property, and testamentary trust must be in writing. Types of trust. Trissy dunks. We went over what that means. D, the duties of the trustee. So yeah, that wasn't on this PowerPoint, but that was on the one we did this morning, and we'll go over it. The duties of the trustee are very important, and Will had a great acronym for us, PUPS, which was PLPS, that you have to have the prudent investor, you have to act loyally, you have to act personally, and you have to separate property. That was really awesome. I love that acronym, PLUPS. We'll go into that, but this was just, I want to go over the materials in my drive to make sure that we're touching everything. Some of these things are really helpful, like this, validity of the trust. We're going to have the settler intent, the trustee, trust race, ascertainable beneficiaries. Very important. Trustee must be 18 years old and competent to acquire or hold property in his own right. In Florida, a corporate entity such as a bank may serve as a trustee. If its charter gives its powers of a trustee, a settler may serve as a trustee, right? So you can be the settler and the trustee. The settler may not be the sole trustee and sole beneficiary, because then there would be no split between the legal and equitable interest in the trust property. That's a good statement. The settler may not be the sole trustee and sole beneficiary, but he can be the settler and the trustee and even one of many beneficiaries. If a co-trustee is unable to perform because of absence or illness, remaining co-trustees may act for the trust. A trust will not fail for one of a trustee. I said this morning. It's a beautiful statement of law. A trust will not fail for one of a trustee. On disclaimer, resignation, or death of a trustee, a court may appoint a new trustee. So I like this a lot. Settler, intent, trustee, trust race, which is the property. Trust race is subject matter of a trust and may consist of any of the following: a loan or in combination. Real property must be in writing. Tangible personal property, intangible personal property. Trust race must be in existence for trust to be enforced and must be properly identified. A mere expectancy will not serve as valid trust race. And trust race must be delivered to trustee at the creation of a trust. Ascertainable beneficiaries, so we have to know who these people are. A valid trust purpose. I said this a lot this morning. That's why it's in bold. In Florida, trusts are presumed revocable unless stated otherwise. Trust cannot violate the Florida rule against perpetuities. We said that Florida does recognize oral trust, but again, not if it involves real property or it's testamentary in nature. Testamentary means it's it has to comply with will formalities because it'll be part of a will. Trust anti-lapse statute is something cool. Florida Trust Code includes an anti-lapse statute for all testimony and inter vivos. Trust anti-lapse suit requires that when a named beneficiary predeceases date of distribution for trust property, there must be a surviving lineal descendant of named beneficiaries able to take property, right? So the anti-lapse statute is going to help these trusts not lapse. A gift lapses if is made to a beneficiary alive at the time of will's execution, but who predeceases the testator. A lapsed gift fails and falls into residue of testator's estate, creating a resulting trust. That's how a resulting trust is created, right? By a gift that's lapsed and someone dies, and then it creates a resulting trust. Types of trust, let's see if they missed any from our Trissy Dunks and things I said. Inter vivos, testamentary, the pour over trust. A pour over trust allows a seller's assets as death to pour over into a trust. Such trust must be created before or concurrently with execution of will and must be in writing and identified in will. Charitable trust, we talked about the Cypress doctrine. If the charity doesn't exist, we'll just switch it for another one. Discretionary trust, right? They have discretion to make payments. And honorary trusts, for my dog. We talked about modification and transfer. Modification, if there's waste, if it becomes illegal, impossible, or economically infeasible. These are reasons why we'll modify it. The Slayer statute is cool. You can't kill someone to take the benefits of a trust or a will. That's just a cool word. That should have been someone's rap name, Slayer statute. I like that. I'll bring that up tomorrow. And then very important, spendthrift provisions. Very important. Florida gives full effect to trust spendthrift clauses. I always call this the Chet Hanks or the Chet Hayes rule. Tom Hanks kid who wanted to have a hot boy, white boy summer. And I don't think that Tom Hanks, if he had passed, would have wanted to support the hot boy, white boy summer. So he would not have been able to, if the creditors from his failed concert would not have been able to pierce the trust if there were spendthrift provisions. So who can pierce it? Child support alimony, claims by the government, and like we said, lawyers or whoever works for the benefit of the beneficiaries of the trust. Prudent investment rule, the trustee is not liable for debt, is not required to pay investors at beneficiary share. Right, we're gonna protect the trustee. Trustee's powers. In Florida, a settlor may empower a trustee to select beneficiaries from a definite class if power exercised within a reasonable time. Trustee can get compensated, right? They may receive reasonable compensation. They have the most important duties, the duty of loyalty, no self-dealing, no commingling, separate near-marked property, duty of prudent investment, diversify investments, duty of impartiality. This is going even deeper than we talked about this morning, which is good. And a breach of a duty, if you violate it, you can get sued for a surcharge. There can be some problems. And you can get removed for, if you're drunk or old, you breach any of these reasons, you can get removed. We talked about modification and removal when we did the valid trust, don't ruin marriages. And then these are some will issues. I'm not going to get too far into this, but this is a great Florida trust outline that I'd recommend people go deeper into. Let's look at the Florida trust rules. Probably just reiterate: settler intent, race, trust proper intent, trustee, ascertainable beneficiaries, valid trust, don't ruin marriages, validity, type of trust, duties, removal, modifications, terminations. Is there a valid trust? There must be intent, trust property, ascertainable beneficiaries, trustee, legal purpose, types of trust, oral trust. This is where he got this from. Personal property worth less than $500. I don't really know what that even is getting at. So it must be in writing when it contains the following subjects. I have no idea what that came from. I think that it should be more than $500, but still I don't even like that statement. Just know real property and testamentary in nature. Discretionary, support, no contest, spendthrift, charitable. We talked about all these things. Duties of trustee is repetitive. Repetition is good. We love a trust essay because we're just going to write about literally all these rules. Prudent investor, loyalty, separate earmarked property, act personally, removal for these reasons, breach of contract, refusal to post a bond, conflict of interest, modification, termination. You can modify when they're acting illegally, wastefully, change in circumstances. Termination, if all the beneficiaries agree, we can terminate the trust. but they're very reluctant to terminate even if they all agree, right? Because it's not the beneficiaries, it's the settler. I have this beautiful statement. The hallmark of trust creation and execution is settler intent. We're always going to try to honor what the settler wanted when he created the trust. You know, this person's probably not alive, and we want to honor what they said. So if we look at a trust essay from, let's say, 2017, look what came about. Valid trust, it must have the following elements: actual trust property, capacity, ascertainable beneficiaries, duties for the trustee to perform, intent to create a valid trust purposes, no sole beneficiary may be the sole trustee. Trustee duties, a valid trustee is someone over the age of 18 who has sound mind and within legal capacity. However, a trust will not fail if there's not a trustee named. A court will appoint a trustee if needed. Any trustee has the option to be a trustee. They may refuse to accept the role in which the court will assign the role to the next one listed or appoint one. Duties, trustees have fiduciary duties they must adhere to, which means they must act in good faith. No trustee may take action that results in self-dealing. A trustee may provide the beneficiaries with accurate accounting each year. A trustee may make investment decisions that benefit the estate, but they may not benefit the trustee. Types of trust: testamentary trust, inter vivos trust. If a trust is notarized, it will be self-authenticating. Revocable versus irrevocable. In Florida, a trust is presumed revocable. They did talk about totem trust, so we can read this. This type of trust is created when there's a bank account attached to the trust, which will make distribution to the beneficiary upon settler's death. Florida's treats totem trust in the same as payable on death accounts, right? That's what I said. This means that the beneficiary predeceases the settler, there's automatic revocation of the totem trust. So just so you know that totem trust is a payable on death account. It's like a bank account. Spendthrift provisions, I told you these always come up. This trust provision is created to protect the assigned assets to the beneficiaries from any third party creditors. The protection only lasts while the assets are still in the trust. Once released to the beneficiaries, the protection is no longer afforded. A valid spendthrift provision is created through specific language according to the Florida statute and must have clear and exact language such as to be protected from any creditor or beneficiary may not assign. The spendthrift provision does have 3 exceptions. Creditor which would be able to take those are creditor for child support, creditor for alimony, and creditors for the federal government. Do you see how repetitive these trust essays are? So, you know, there's definitely some more things that you could go through in here, and you all know I always update the materials in the course. So the course materials will have trust down to a science. But one thing that I do like to look at is some official essays and model answers, maybe just 1 or 2, because trusts are so repetitive. We did 2017. That was my year. That was the year I took the bar exam. And I was so happy when I saw this essay, even though it says trust, family law, dependency, ethics, I knew that I could crush the trust. I could crush the trust piece. So if we look at 2019, you know, blah, 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 a trust. Okay, we see a trust. And they talk about the trust. Let's see what happens in the model answer. They set it up just like I always like to. 2 from Ree. Ben has asked for my legal advice, analyzing these claims, and the claims are literally straight from the model, from the called the question, right? The validity of the trust, the claims, and the likely outcomes. So the validity of the trust, the claims, the likely outcomes. The validity of the trust, straight, like, it's going to be very repetitive, but repetition is the key to passing this exam. In order to be a valid trust, a trust must be executed with proper formalities by someone with capacity to execute the trust with trust assets, which is known as race, with the intent to place those assets in a trust, a lawful purpose for a beneficiary, and administered by a named trustee. Do you see how we've said it all kind of differently? But it's okay, just say it as good as you can remember and try to get those main points. With respect to formalities, if a trust has a testamentary effect, it must comply with the formalities of a will, and if it disposes of real property, it must comply with the statute of frauds as applicable to all real property transfers. This trust is not testamentary and is not irrevocable, therefore the will formalities, namely the signature, blah, 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 do not apply, and there's no indication that it's improperly executed. However, because the trust involves the deed of real estate, the commercial building, the statute of fraud must be satisfied. So as for land, it needs to be in writing. Turning to the requirement for all trusts, there must be capacity, right? They have to Be smart. There's no indication they lack, not smart, but not incapacitated. They must have race. Like, do you see how they go through it? They must have capacity. They must have race. They must have the intent. And they had all these. They must have a lawful purpose. They must have a trustee. Boom. And they go through it. Usually these elements will be satisfied because we want to continue on with the essay. The next question is whether they revoke the trust. Florida, of course, they're assumed revocable. But here it was made revocable, so they had the power to revoke it. So they're talking about whether it was revoked or not. In some, it appears to satisfy the requirements to create the trust and not to have been revoked, and therefore is valid. So it was revocable, but it wasn't revoked. Now they're claiming that it was revoked. They're going to claim fiduciary duties. Remember, we always talk about the duties and that the trust should be terminated. The first is likely to succeed. The second is not. Regarding breach of duty, as a trustee, Ted owed 2 sets of duty to Ben as beneficiary: duty of loyalty, duty of reasonable care of the administration of the trust assets. With respect to duty of loyalty, it's a per se violation to engage in self-dealing. Therefore, he breached his duty of loyalty when he sold to himself the building held in trust for Ben, right? So he did some bad things here. That's what you're looking for in a trust essay. The trustee is always going to do some bad things. The second claim is he breached his fiduciary duty by hiring his wife, right? Now should we terminate the trust? It should be terminate consistent with the settler's intent, right? The settler's intent is always going to be paramount. So long as the settler is living, this may be done with consent of all beneficiaries and the settler. However, the settler is dead. When the settler has died, the trust may be terminated by unanimous consent of the trust beneficiaries, so long as it would not conflict with the material purpose of the trust, right? Among material purpose are spendthrift clauses, which they talked about. Spendthrift clauses constitute a material purpose. There are some question whether it's a proper spendthrift clause. Distribution. In some, Ben has a strong claim against Ted for breach of fiduciary duty based on a sale of the building to himself, but not based on hiring his wife. He can recover personally for Ted against the difference between the market value. Again, they may also seek the court's permission to remove Ted as trustee, and they will succeed, but they're going to likely stop short of terminating the trust because, it's going to conflict with settler intent. Wilma wants to be seeking to be paid alimony, right? Alimony is one of the things that can pierce a spendthrift clause. I told you, they always talk about spendthrifts. So they define what a spendthrift is. They talk about tax liens, alimony can pierce a spendthrift. So maybe her alimony was void in the first place, but if not, they're going into marriage, which we're going to go into family law. They went to some marriage and family law things, which we're about to get into in about 5 minutes. But in conclusion, trust appears to be valid and unrevoked. He'll not be able to terminate it. He has a claim for Ted for breach of fiduciary duty and to replace him. And then Wilma is an exception creditor to the spendthrift provision, but she'll face some difficulties because, I don't know, we didn't read the facts of the question. But do you see the main parts of this trust essay were got with, do you identify whether it's a valid trust, the duties of the trustee, spendthrift provisions, just kind of going through that valid trust, don't ruin marriages. Let's look at one more trust outline before we move to family law. But you see how trust and family law are often tested together. So here, la-di-da-di-da-di, they set up a trust. They set up a trust. Let's go into the answer and see what they have. First, I'll address the life insurance proceeds. It appears that it was breached when he named his ex-wife the sole beneficiary. We'll see what happened. When a promise is breached, they can impose a constructive trust. Constructive trusts are meant to equitably allocate trusts under 5 situations: theft, breach of fiduciary duty, homicide, breach of promise, and fraud. This is nice. So he's talking about constructive trust. But then he said this argument will probably fail. Then he gets into the main thing. I will address the characteristics of the trust. This is coming in on every single trust essay, and this is why we love trust, because if you can memorize this and just go through it and see if it's happened, then you're going to do very well. A valid trust requires 7 elements: settler, intent, trustee, beneficiary, sole trustee can't be sole beneficiary, trust property, and valid purpose. There are 2 kinds of express trust, private and charitable, and trust can be either inter vivos or testamentary. Finally, trusts are presumed revocable unless expressly stated otherwise. Really great. Resulting trusts are not actual trusts, but they're a result imposed by courts to dispose of a purchase money trust, to pass a beneficiary's interest if a gift lapse, or dispose of the corpus of a trust. So he talked about resulting trusts. Comes from Trissy Dunks. I liked what Will said. He said he'll just name all the trusts, define them quickly, and then talk about what these trusts are, what trust this is. Here he's talking about who the beneficiaries are, they're ascertainable, and then always trustee duties. Duty of loyalty, duty of care, not to commingle, not to self-deal, duty to make good investments, diversify, etc. He can be removed, right? Valid trusts don't ruin removal. We're going to talk about ways to remove them. And then maybe a question about modification. They're just really going into the elements of the trust and see if they were valid or not. You know, easy, right? I really propose to all of you that trusts is an essay topic that you're praying for. I'm going to have organized for you in the drive, and I'll just remind everyone what it kind of looks like. But I'll have organized for you all a very concise but complete trust folder that has this video, but also the materials. So if you look at like the crash course and you look at materials, we're going to fill up the trust one just like we filled up contracts. And what it has is all the essays and model answers, the PowerPoints, the rules, the questionnaires, the model essays, everything. And if we real quickly just look at the torts questionnaire, you can see, I'm sorry, not the torts questionnaire, the trust questionnaire, you can see everything that you would think, necessary elements of the trust, the different types of a trust, what are their definitions, are they presumed revocable or irrevocable in Florida? Obviously revocable. What are the duties of the trustee? When may a court remove a trustee? What are spend-through provisions and who can pierce them? What's the cypress doctrine? What is necessary for modification of a trust? What is necessary for revocation of a trust? When does a trust need to be in writing? What else is important to know about trust? That's a simple 10-question questionnaire that if you can confidently answer, you're going to do really well. Anyone have any questions about trusts?
So the only question I have is for testamentary trusts, which are obviously it's created by a will. I guess what's the distinction between it being a testamentary trust or a secret or semi-secret trust? Or will a testamentary trust be also a secret or semi-secret trust?
Well, the main difference is the secretiveness of it. Where a testamentary trust, everyone knows like your benefit. It's not like you died, they found your will, and they're like, oh, it's whether it's the first time it's mentioned. Semi-secret and secret trust refers to it being the first time that's mentioned. A testamentary trust is a trust that like they all knew was going to be part of your will. So
they're saying, hey, we're creating a trust.
Right. In effect, a secret trust is a testamentary trust. It's just the first time it's ever mentioned, and that's why it would be enforceable. But it has to be in writing, and it would be in writing as long as the will complied with will formalities.
Okay, gotcha.
Just make sure everyone's got the main deal on trust, identifying the trust, what are the necessary elements of the trust, what types of trusts are there, what are the duties of the trust, spend-through provisions, who can pierce a spend-through provision, how can we remove, modify, terminate. Solid, right? Everyone's more than happy with trust, and we're like praying for a trust essay on test day? Would you say, or I mean, when you go back and review it, but for now, you all agree with me that trust is not that bad.
Yeah.
You can memorize that. All right. Let's go into the other half of today, which is family law, which, in my opinion, is tough. Not my favorite subject, but can't really complain. We just have to do. So this was a PowerPoint that will supplement Will's PowerPoint. So we'll have two PowerPoints in the drive, and nothing new. This was made by one of my former instructors, Letty. She's awesome. Family law is a body of law, often tested rules, trickier issues. Introduction to family law, very few testable mini topics, right? That's why I don't like it. That's why I say real property. Often comes up with property, trust, and professional responsibility. That's facts. Factor heavy, numbering heavy. Like these are the factors of alimony. These are the factors of equitable distribution. Sure. Subject matter and personal jurisdiction. We talked about that with our acronym NJV piece. Love story gone wrong, beginning, middle, end, and some equity. That's a good way of thinking about a family law. It's a love story gone wrong. Marriage, divorce, property, kids. Sounds like everyone's life story. Not everyone, but a lot of people's. Okay, no fault divorce state. In Florida, a couple may divorce if the marriage is irretrievably broken, if one spouse becomes mentally incompetent. The court may continue proceedings for 3 months to allow for the couple to reconcile through counseling. Discuss one or both elements if relevant. This is important. This is the thing that I wanted to clarify. Subject matter jurisdiction. One spouse must be a resident of Florida for 6 months before commencing an action. Look for the 6-month rule. Usually this is how you know they're testing this. Right? They'll be like, he lived there for like 5 months. Personal jurisdiction. Based on the person's physical presence in the state, property located in the state, or minimum contacts. Notice of complaint is required. It's a normal analysis on personal jurisdiction, right? Minimum contacts. So they've been a resident for 6 months and they have PJ over them. Marital agreement, really divorce agreements. There's a prenup and a postnup and a separation agreement. The biggest difference between the prenup and the postnup is the date of creation. A prenup is signed before two people are married and a postnup is signed after. I feel like I'm teaching to kindergartners, but this is true. Premarital agreement, the main idea. It outlines the division of property, alimony, spousal support, and consideration of marriage. It's got to be in writing, right? Because it's in consideration of marriage. Parties, postnup is after, you're going to define things. I think statutorily a postnup is supposed to be in writing too in Florida. Separation agreement, Trouble in Paradise. That could have been someone's album. Usually defines allocation of property, spousal support, child support, parental responsibility, and time sharing. So you have a marital agreement, but is it legally valid? A premarital agreement is enforceable if there's a full disclosure of all your stuff. Will be closely scrutinized for good faith, undue influence, fraud, duress. Good faith, look for, good faith is fraud, undue influence, duress. We already did this in contracts. Voluntary, right? Like R. Kelly probably did not have voluntary marital agreements. Must be in writing and signed by the parties to be charged. I was just thinking about this one guy that everyone's talking about in the news, Andrew Tate. I don't know if he's married or not, but his relations with women seem not so voluntary. Equitable distribution of property is not 50-50 always. So goal, a fair and equitable distribution of marital property. That's what we're trying to do. To do this, we take into consideration all circumstances. There's millions of factors. It's not always 50-50. What is marital property? Important. Marital property is all property acquired during the marriage, which includes active appreciation, increase in value of all non-marital property during the marriage as a result of the efforts of either spouse or contribution to marital funds or assets, right? So like you had an account before the marriage, but then it grew during the marriage. Probably the growth is marital property, not the account before marriage. Non-marital property is not property born from love, usually born before marriage. Most common example. I didn't mean to laugh at love. I love love. Property excluded by property's valid agreement, gift, or inheritance, right? If you're specifically bequeath something from a will, it's probably going to be non-marital property. If you had it before you got married, non-marital property. These are important factors for equitable distribution, factors on factors. Factors to consider for equitable distribution: length of the marriage, economic circumstances, contribution of each spouse to marriage, contributions one spouse to education or career of the other spouse, interruptions to either spouse's personal career education, interest of one spouse to retain marital residence for dependent children, any factors the court finds necessary and just, retirement or pension benefits, marital property if acquired during marriage. Look out for this one. It's not as obvious and often tested. Professional licenses, degrees, not necessarily a property interest, i.e., but I was your wife during your entire miserable 3 years in law school. I dealt with your BS. That is true. It's not a property interest though, right? So that's just a good point. This is a discussion. That's the good thing about family law. It's a discussion. You need a good family law lawyer. From my experience, usually the women win for most good reasons, because there's a lot of hard work that goes in child rearing and raising a family, and that deserves to be justly compensated. Okay. Alimony, very important slide. Everyone must memorize these. Bridge the gap, transition from marriage to hashtag single life. Rehabilitative, limited time period so you can get it together. Permanent, usually old couples. Award for remainder of the dependent spouse's life. The key is a long duration, usually 17 or more. Durational, typically awarded when the marriage was of short or moderate duration and economic need for support. Pendente, only during time of separation until the marriage is dissolved. Yo, here's $5 so we can get divorced. Oh, we have someone who joined us. Okay. And write about all of them plus factors. Number them and apply only the relevant factors. What about those kids? Shared parental responsibility, best interest of the child. Best interest of the child is the primary standard for all matters relating to parenting, time sharing, and support. Both parents involved is the goal. Remember, it's not custody, it's time sharing. Whenever possible, the court wants both parents to be involved in raising a child. There's no automatic preference. A parent may forfeit the right to shared parental responsibility by being a really, really bad parent. It is rare that a parent will have no right. In Florida, we want to give you some time with daddy, even if daddy's doing wild stuff. Right now, we're thinking of Kanye West and Kim Kardashian. They just got divorced. Even then, I'm sure Kanye has some visitation rights. I'm not saying he's not a bad parent. I don't know, but I'm just saying, like, we want them to both have some rights. So parenting plan, the parenting plan will describe how parents will share responsibility. You definitely want to talk about the parenting plan. That's a big thing, the parenting plan, right? There's a lot of these sub issues. The parenting plan will have the time sharing agreement, designation of who will be responsible for healthcare, school-related matters, etc., and methods the parents will use with the child. When you're doing these family law essays, you really want to act like the family law attorney and be like, look, wife, husband, non-binary spouse, this is the situation. These are all the factors at your disposal. This is what we're going to need to do. This is, the whether we have jurisdiction. This is whether there's going to be a child support or alimony. This is going to be the parenting plan. This is what's going to go on the parenting plan. These are all the factors. Like, really try and explain it to a client. Don't move the kids. Oh, look at these kids. Relocating, removing a kid from the state. UCC JEA jurisdiction, right? Up to 49-mile rule. Oh, we didn't talk about this morning. Very important. No need for permission from the court or other parent if you're going to move them up to 49 miles. But more than 50 miles, you need written consent of every person entitled to time sharing, or serve a petition to relocate of every person entitled to time sharing. The petition must include details about the move, date, location, reason, etc. Must include a proposed revised plan for time sharing and transportation. There's no presumption in favor or against a relocation. The standard is always the best interest of the child, even if time sharing will be substantially affected. The goal is to always have those faces, right? We want to have these happy little kids. Any questions? All right, that was a super good slide. And how crazy is this? When we made this PowerPoint, he was still alive and he recently has passed. And unlike the last slide, I know who this person is. Success is no accident. It is hard work, perseverance, learning, studying, sacrifice, and most of all, love of what you're doing or learning to do, by the late, great Pele. So cool. This was a good PowerPoint. I'll definitely add this to the materials for this crash course. And you saw there's a lot of things that we'll discuss this morning and a lot of things that we talked here that overlap, and then some things that we didn't grasp. So that's why it's always good to come, to all parts of the class or to listen to all the videos quickly. And, I'm going to go through everything. The rules. Divorce. Are the parties able to divorce? Florida's no-fault divorce, irretrievably broken. We can attempt to order counseling to reconcile, counseling, continuing proceeding for 3 months, or other actions in the best interest of the child. We talked about jurisdiction to hear a family-related dispute. The court must have SMJ and PJ over the parties. SMJ, one spouse must have lived here for 6 months before commencing the marital action, matrimonial action, and PJ is going to be the same as it is in a civil procedure, right? You have to have minimum contacts, service, or property located in the state. We've enacted the UCC-JEA, which prevents jurisdictional disputes with courts in other states or matters of child custody and visitation. It requires that the court possesses subject matter jurisdiction. Initial custody. A court has subject matter jurisdiction over custody hearings and either entry or modification, custody or visitation orders if the state is the child's home for a period of 6 months or since birth, or was the child's home state in the past 6 months and the child is absent from the state, but one of the parents or guardians continues to live in the state. Rule 3, equitable distribution of property is equality, not necessarily 50-50. only marital assets are subject to division. Non-marital assets, assets acquired before the marriage by individual spouse, assets gifted or devised to an individual spouse during marriage. We talked about that. Marital assets and anything acquired during the marriage. Factors considered when dividing property: contribution to the marriage, duration of the marriage, career and education, sacrifice, etc. Alimony, I like this, sad fret me. These are the factors for alimony: standard of living, age, duration of marriage, financial resources, responsibilities for the minor child, earning capacities, tax treatment, marital contribution to the marriage and education of children, equity, professional and academic sacrifices. Pendent lite, during the lawsuit, temporary alimony, suit money, covers the immediate living expenses, right? That's suit money. Pendent lite, bridge the gap, going from marriage to single life. Rehabilitation, that's training to rehabilitate them for certain circumstances. Durational is for a set period of time. Permanent, long marriage is 17 years, moderate marriage is 7 to 17, short marriage is under 7. Shared parental responsibility, the best interest of the child. These are some factors involved. Whenever possible, we want both parents involved. We want to have a detailed parenting plan that has time sharing, designation of who's going to take care of what and for why. Remember, there could be sole parental responsibility, there can be shared parental responsibility, or what's the term again, Joel?
It's sole, shared, and ultimate.
An ultimate is where, like me, I'm the teacher, I'll make sure I'm in charge of little Johnny's math, and my wife is the athlete, she'll be in charge of little Johnny's basketball, right? Okay, we just talked about this. If you're going to move over 50 miles, you need consent from everyone. Always talking about the best interest of the child. We talked about the prenups and postnups. Paternity. Florida presumes paternity when the test results are over 95% true. Courts may order genetic testing of the child. Biological mother, right? That's the Mari, you are the father. Adoption, the legal effects of adoption is like you birth the kid. The adopted parents possess all rights and responsibilities of biological parents. Birth parents do not have visitation rights with the adopted child. We don't do dependency anymore, so you don't need to know about any of those things. But that's, again, a lot of issues in family law. That's why it's not easy. But the one saving grace when you do family law is the best interest of the child. And just, come on, we've seen television. We know how these things go, how divorce proceedings play out. So here's a 2013 family law, Florida common law essay. Let's see what happened. Personal jurisdiction, UCCJEA, the Uniform Child Custody Jurisdiction Enforcement Act. In order for a party to file this type of action in Florida court, the party has to be living in the state for at least 6 months. In order for the court to have personal jurisdiction over the opposing party being served, the party must either be a resident of the state or there must be a basis for personal jurisdiction pursuant to Florida's long-arm statute. Florida's long-arm statute analyzes the party's contracts in the state, for example, whether the party owns property or does sufficient business in the state. When action involves a child, jurisdiction will be based on the UCCJEA. The state that issued the first order regarding the child will always have continuing jurisdiction to modify. That's what I was trying to get at this morning. Whoever issues you file a divorce in Florida and then you want to modify it, Florida has continuing jurisdiction. However, jurisdiction can also be established in the state where the child and at least one parent have resided for the last 6 months. If this cannot be established, Florida could still take jurisdiction if no other state wanted to take jurisdiction of the case. Modification of time sharing. In Florida, the court enters what is called a parenting plan in order to address every detail regarding time sharing. This parenting plan includes the time each parent will spend with the child, the extracurricular activities the child will participate in, travel arrangements for time sharing, who makes decisions over the children, whether those decisions will be shared, and every other issue that would affect the well-being of the children and affect their best interests. The parenting plan is normally referred to in the parents' marital settlement agreement, where there is a divorce and there is therefore incorporated into the final judgment. In order to state a proper claim for modification of time sharing, the party seeking the modification must allege a substantial change in circumstances that is permanent, involuntary, material, and unforeseeable at the time of the final judgment. The best interest of the child always govern. Although Florida statutes provide a lengthy list of factors that are considered when analyzing the best interest of the child, the usual factors that are mostly issued by the court are continuity for the child, how likely the other parent is to encourage and foster a meaningful relationship with the other parent, the child's preference, which is weighted heavily when the child is still a minor, but older and able to express himself regarding his wants and needs, right? Let's just ask the kid, Do you want to hang out with daddy or mommy? Who's better for you? The ability of each parent to care for the child, and any past history of substance abuse or any other type of abuse. Modification of shared parental responsibility. In Florida, there are 3 types of parental responsibility. Shared parental responsibility is when both parties are charged with equal decision-making over the children. Anything related to the children, including their medical treatment, schooling, and upbringing, would be jointly decided by both parents. This is the norm, as both parents have a constitutional right in Florida to participate in the upbringing of their children and the joy of child rearing. Sole parental responsibility is given to only one parent when it's found that the other parent is detriment to the children or is otherwise unfit and unable to provide care for them. This vests all the power to decision-making over the children in one parent. There's also parallel shared, that's what I call it. That's why I was confused with ultimate. I like the word parallel, but ultimate's cool. The ultimate. Where there's responsibility split, but according to subject, right? I'm doing tutoring, my wife's doing football. Well, I don't know about my wife doing football, but maybe. I'm not married yet, so I could marry a football player, we'll see. For example, if one parent is a doctor, the court could allow that one parent to make all the decisions regarding the child's medical care, like we just talked about. Shared parental responsibility, according to topic. The standard is best interest of the child, as described above. The person seeking the modification has to allege a substantial change in circumstances, as well as factors that would render the parent unfit and detrimental to the child. Modification of child support. In Florida, both parents are obligated to contribute to the support of the children, regardless of whether they are married, separated, divorced, or never married at all. Child support is primarily based on need and ability to pay. The court will look at the respective incomes of both parties, the health insurance that is being paid for the child, the necessary child care costs, and the time sharing being exercised by both parents. Florida has statutory guidelines regarding what child support should be based on the parent's income. If one parent is spending more than 30% of time with the child support is calculated using a gross up method, which gives that parent the substantial amount of time a higher amount, right? This is getting into the gross up method and child support and certain things. You don't need to get swept away in this, but it's okay to hear. A court can deviate only 5% from the child support guidelines after considering relevant factors and with specific findings of fact that would justify the deviation. This is the statutory language. In order to seek a modification of child support, the party seeking the modification must allege a substantial change in circumstances. The change would not need to be one of the factors that is used to calculate child support: income, healthcare costs, child care costs, and or time sharing. The modification would date back to the filing of the petition. This means that if the child support is modified to a higher amount, the difference between the established amount and the new higher amount would be collectible from. Okay, again, main things is just like MJ or what was it?
Yeah, you're on it, MJ.
MJV piece. Yeah, MJV piece, right? Modification, jurisdiction, venue, parenting plan, equitable distribution, alimony, child support, esquire fees, and what did D stand for?
Dissolution
marriage. All right, cool. I mean, I'm trying my best to be mnemonic, but it doesn't matter. There's a lot of ways to learn a lot of things. So the last thing I want to do is, real quick, last 2 things I want to do very quickly. The family law questionnaire, what's on this? You know I'm going to ask everyone to master this at some point, but is what type of divorce state is Florida? No fault. What's necessary for SMJ, for PJ? How is marital property divided in Florida? What factors determine alimony? What are the different types of alimony? What's considered in a time-sharing agreement? What's included in the parenting plan? What's necessary for modification? What's necessary to relocate a child after divorce? Elements of a prenup and a postnup? How do you determine paternity in Florida? The legal effect of adoption in Florida? And anything else, right? Again, a lot of these factors, this is a very factor-based analysis right here. And I seem to have lost my lighting, but this is, very factor-based, and you want to make sure that you understand the different factors of family law and things of that nature. So let's just look at one essay, and you'll see that these are the issues that come up and come up often. And I'm going to turn back on my light. Okay. So Florida family law, Florida family law. And let's just look at July 2003. Just give me 1 second. Okay, so we have this Wanda and we have Howard, and they are little fairies that are on your, wasn't that the names? Wanda and your godparents?
Wanda and, oh my god, I'm forgetting. Cosmo.
Cosmo, yeah. Wanda and Cosmo. All right, just real quickly, it's about family law. Under Florida law, marital property is distributed under equal distribution. It requires that property is divided 50-50 unless justice requires. Marital property includes assets during the marriage, interspousal gifts, pension plans. It considered these factors. Talking about the marital property first. Second is alimony. Under Florida law, they may receive alimony. There's different types: periodic, lump sum, rehabilitative, and temporary. These are the factors. The third issue is with the adoption. Under Florida law, adoption makes someone, the same as a biological child. Next, they're going to talk about child support. They're going to talk about custody. We don't use the word custody anymore. We use sharing, time sharing, best interest of the child, child's preference, and all that for the time sharing. Share responsibility. Equally responsible for the care of the child. You can deviate 5% from the statutory guidelines. That was it. Super, super simple. Just because I want to see something very quickly from a little bit closer, let's look at 2018. Again, this one had dependency, so dependency is not going to be something tested. So it won't be that legal obligation to report or anything. But look, termination of parental rights. Oh no, that's going to be dependency. It's not going to be that. But adoption of children, when you can adopt children. Grandparents have a right to. Florida gives protection to grandparents. Again, I think that's dependency. That was a bad one to look at. Let's look at.
I think there is something in there that, like, if the grandparents do have some sort of
they do have rights. Florida does protect. Yeah, grandparents have visitation rights. We like grandparents. So again, this last one that we'll look at just for a minute. Florida's a no-fault divorce state. Make sure we've taken that out of this. Prenups must be in writing to satisfy statute of frauds, and there can't be any undue influence or anything like that. Florida is equal distribution. Marital assets are 50-50 unless there's an unequal claim. And we have the difference between marital and non-marital assets, including the 401k and pension plans. Equal distribution factors, easy. They did a little bit about homestead exemption here. Alimony, factors for alimony, temporary alimony, periodic alimony, rehabilitative alimony, lump sum alimony, different factors for alimony. Child support, alimony, same old stuff. 2020, we saw real property and family law, talking about divorce, equal distribution, alimony, child support, and then this is a real property one. So again, make sure you know alimony, child support, divorce, and those type of things. I think this was a good, quick re-review of family law and trusts, which are two topics that don't always come up, but when they do come up, if you have the elements memorized and you can recite them, you're bound to do really well. Anyone have any questions about family law or trusts? You just got to review it, memorize it. Next week, we're going to take a break from essays and we're going to tackle the multiple choice subject. So that's going to be a whole lot of fun. For those of you who are coming to my MBE course, I will see you tomorrow. I hope everyone is rooting for the Birds, my favorite team. And thank you all so much for joining me. It's been a pleasure.